Francisco and John Meyer, folks at Pendle Hill. It's always great to be back here. Been here several times, as Lena mentioned, and always just feels like I can feel my nervous system downshift when I get on the campus here. It's a calming, lovely place, so thank you. I'm Chad Nicholson, the Pennsylvania State Organizer for the Community Environmental Legal Defense Fund. We are a nonprofit public interest law firm. I am not a lawyer. I get accused of that all the time, but I'm not a lawyer, so just so folks are aware. I am an organizer. And the briefest overview of my work is that I get phone calls from people on a weekly basis who are facing really nasty things that are being threatened for their community. So a lot of it is environmental, things like factory farms, the spreading of sewage sludge on farmland, fly ash being dumped into communities. These days, a lot of it's natural gas infrastructure like pipelines for export, such as the Mariner East 2, which is not too far from here. The Atlantic Sunrise Pipeline down in Lancaster. Injection wells to take frack waste that comes from the fracking operations, still longwall coal mining. The list goes on and on. In addition to the environmental issues, our organization is now working more in urban areas as well on more social justice related themes. So we're getting calls about folks who are upset about campaign finance and how corporations are influencing elections, not just at the state and federal levels, but also at the local level. Worker rights and minimum wages have been things we've been getting more involved with. I've been working hard on a group out of Philadelphia recently called the Human Rights Coalition, which is working with incarcerated folks on what they're calling a prisoner bill of rights, which is about prison abolition and actually making sure that the people that are incarcerated have more rights and protections than they currently do. So our work has expanded out from the environmental work where my organization started. I'm not going to get into too much of that tonight. I'm going to be talking more about, as Lena mentioned, what we're calling rights of nature. And how that movement has started in rural Pennsylvania, not too far from here, and how within about 12 years it's actually become a global phenomenon where it has expanded out of Pennsylvania into about 10 or 11 states across the country and into 13 or 14 countries that are taking up rights of nature in various capacities. So I want to talk a bit about what rights of nature means tonight, what it means when we say rights of nature. How can an ecosystem, a watershed, something like that actually have rights? What does that mean? And how has that movement spread? And I think for me, the conversation around how that movement has spread is in some ways the more important part of it, because it hasn't been the smart people in DC, smart people, it hasn't been our bureaucrats, it hasn't been the United Nations, it's been the hard work of people at the local level who have been doing really creative and tireless resistance that has actually spurred this to spread across the globe. So that's in many ways what I want to focus on tonight. Not going to talk too long tonight. I mean, we'll have a discussion and then hopefully do Q&A at the end of it, as Lena mentioned. I usually start talks like this with a bunch of depressing news. And I'm going to get to some bad news, but I thought tonight, because I'm in a good mood, we'd start with something a little more upbeat. I am in a good mood. But first, a couple of questions. Who is bummed out or sad about the current state of the environment? Anybody not? Okay. And who, when they think about the current state of the environment, sometimes feels powerless or helpless to actually do anything about it given the scale of the problems? Okay. Most people not. Lena has to be the rebel. So with that in mind, I'm going to tell a little story about a community called Tamakwa Borough. It is in Schuylkill County, about an hour and a half north of here or so. Small borough, a few thousand people, that is located in what's often called the dumping grounds. There's actually an article called The Dumping Grounds of Schuylkill County. It's had coal mining and a lot of acid mine stuff over the years. These days in that area, a lot of stuff gets brought in and dumped into the old mine shafts. So sewage sludge from places like Philly, Newark, New Jersey, New York City. I don't know if folks are familiar with what sludge is, but basically it's anything that's flushed down a drain and ends up at a municipal wastewater treatment plant. It can contain hospital waste, industrial waste from whatever industries are upstream, can contain radioactive material. The liquids get separated out from the solids. The solids are called sludge cake, and they can contain up to a couple of 100,000 toxic contaminants. The EPA tests for a grand total of 9 of those, and if those are not present, then they label it safe for use on farmland as fertilizer. A lot of sludge is getting brought into Schuylkill County. Also fly ash, which is a byproduct from coal-fired power plants, which is toxic and has been known to have a lot of carcinogens within it. So a lot of these materials were being slated for Tamaqua Borough. This was back in 2005, and we began working there with a local school nurse named Kathy Miarelli, who was also on Borough Council. She was upset about these things coming in. She saw a lot of the health concerns already, given what the environment's like in Schuylkill County and the students that she was working with, asthma, higher incidence of cancer in the area. And she didn't want more crap being brought in and dumped in her community. She found that she didn't really have any legal remedies under the law to say no to these things. I'm going to talk more about that in a few minutes, but basically, all of these activities are legal right now. To dump sludge, to run a pipeline through your community, to dump fly ash, to put a frac waste injection well in your community, all those things are legal, and they're given permits. The company is given permits by our state or federal environmental regulatory agencies to dump this stuff. So Kathy and her group and her borough council were concerned because they didn't want more stuff coming in, more contaminants, but they were told they couldn't stop it because these things are legal under state and federal law. At that point, she and her group decided they basically had to take matters into their own hands, and they said, well, we don't care if the state tells us it's legal, and we don't care if the state tells us we have to take it. We're going to use our local lawmaking authority to enact a law that prohibits it as a violation of our rights as community members, that we have rights to have clean air and pure water, and we're going to ban it as a violation of those rights. And in addition, she, with her leadership, took one step further and put into place rights of nature. In 2006, in Tamaqua Borough, small rural borough in what is coal country and most folks would call Trump country. First community on earth to give rights to nature. First community in the world that gave legally enforceable rights to nature. It reverberated around the world. Some folks were just laughing at it. Some folks thought it was ridiculous, but I mean, it got a lot of attention. Others were very intrigued. How would this actually work? It actually made it down to Ecuador, where a number of nonprofits, NGOs located within the country of Ecuador, contacted our organization, and they invited us to come down and advise their constituent assembly, which was tasked with writing a new federal constitution at the time. So our organization traveled down there. They heard what happened in Tamaqua Borough. We went down there and we worked with their constitutional assembly on language for rights of nature, just thinking it would be a good exercise and really expect it to go anywhere. They put that national constitution up for a vote in 2008, and it passed with an overwhelming majority in that country, and rights of nature then became enshrined into Ecuador's national constitution. So just to think, when we find that the problems facing us and confronting the world right now may be overwhelming, and that the actions that we take in our communities may not have any real impact, I always come back to this story. In some ways, it's what keeps me going, to think about the actions of one small community, bold actions, thinking outside the box, not accepting that they have to take the crap that's being forced on them, and putting into place new structures of law and putting into place new crazy radical ideas, actually then influenced another country's national constitution just a couple of years later. So things can happen. That's the lesson for me out of this stuff, is that if we actually act on what we know is right, put ourselves out there and take bold action, it can influence others. Maybe, I don't know, some folks don't always find that inspiring, but for me it is. And some folks then want to say, well, has it done anything? Does it actually work, or is it just pretty words on paper? In Ecuador, the first time that the rights of nature were upheld were just a couple of years later. There was a case brought in 2010, I believe it was ruled on in 2011, regarding the Vilcabamba River, which was being violated by the expansion of a highway project that the government was funding. So they were dumping all of this crap into the river. It was altering its flow. It was basically like damming the river. And a couple of people in Ecuador brought a lawsuit on behalf of the river, sued the state for the expansion of the highway project, and the court actually ruled in favor of the river, that the highway project expansion was violating the river's rights to flow and to be free from interference, and they stopped the highway project. Since then, there's been a number of other cases. There's smaller courts that are getting set up to deal with rights of nature cases. I'll get into that a little bit later tonight. But I just wanted to start with what I think is an uplifting story before we get into some other stuff here. So There is a lot of bad stuff going on, and I hear about it every week. And I mean, climate change, I feel like every report I hear every week tells us that, it's accelerating at a faster rate than anybody ever thought, and that it's gonna, originally just gonna be 2 degrees warmer by the end of the century. Last I heard was 7 or 8 degrees, and everybody's saying that could continue going up. Species extinction is continuing to accelerate at unprecedented rates. We have harmful activities continuously being forced on our communities against their will. Melinda's been fighting a pipeline. How many folks in here have been active or aware of the Mariner East pipeline? Right, so Sunoco company putting a pipeline through a bunch of communities. Sunoco has a terrible track record when it comes to environmental protection and to their permit violations. And yet they keep putting it through, and the best our communities can do and the best our Department of Environmental Protection can do is just fine them, as if the monetary costs and the monetary damages are enough to make up for the danger that they're putting these communities in, and for the loss of property and for the loss of life that goes along with this stuff. So, the list goes on and on. I don't need to sit here and go through all the harms, but just to say that there's a lot of nasty stuff going on. And for us as an organization, we had to come to grips to that and ask some pretty serious questions, which is, why is it that so much bad stuff is being forced on our communities against their will? Why can't they stop these things? Why can't the people that live in a community come together and just pass a law that says clearly this activity is going to violate our rights to health and safety, and clearly this corporation usually has a long list of permit violations, and yet their corporate board of directors is given more legal rights and privileges than the majority of people who live here and raise their families here and work here? And why is that? Well, and why can't we enforce our environmental laws? I mean, we had an environmental revolution of sorts back in the 70s on the heels of rivers catching on fire, like the Cuyahoga in Ohio. Harms cancer clusters all over the place. There were things that people could no longer ignore, and we had this alphabet soup of new environmental protection laws that got put into place in the early 70s at the federal level and at the state level. We had the Clean Water Act, the Clean Air Act, the National Endangered Species Act, the National Environmental Policy Act, all this stuff, which most folks thought was going to usher in a new era of environmental protection and really change how our communities, really change the balance of power, so our communities could actually protect themselves and no longer have to take the bad stuff that they didn't want. And some of the language that I think is worth reviewing quickly comes from the Clean Water Act. So passed in 1972, the one I want to look at here is Section 1. This is in the preamble to the Clean Water Act. It is a national goal that the discharge of pollutants into the navigable waters be eliminated by 1985. Sounds pretty good. And yet today, from a recent EPA report just in the last couple of years, over half of the waterways and rivers in the United States cannot support healthy aquatic life. An additional 20%, so that brings us up to about 80% of rivers are only seen as fair quality, and there's question of whether or not it's safe to swim in those or to eat fish from those. So the intent of the law passed in 1972 was to eliminate all pollution going into the waterways by 1985, and yet even today, according to the EPA, the agency that's supposed to be enforcing these laws, by their own admission, we now have half of the waterways in the United States that can't even support basic aquatic life or health. Why is that? Well, we had to learn that answer to that question the hard way. So the work that the Legal Defense Fund does now is very different from the work that we started out doing. We opened up in 1995 as a nonprofit public interest law firm to provide free legal services to, at the time, mostly rural communities across Pennsylvania. So our executive director and co-founder, a guy named Thomas Lindsay, came out of law school, and in law school, he was taught that we have the best environmental laws in the world, in the United States. Our laws are so good that we actually export a lot of our legislative frameworks out to other countries so they can model their own environmental legislation on our great stuff. That's what he was taught as a lawyer. So as he looked across Pennsylvania and saw all of this nasty stuff being forced on communities that didn't want it, logically he thought to himself, well, if we have such great environmental laws and yet all these communities are getting polluted, then there must be one of two issues going on. Either we don't have enough lawyers, we no longer think that's the problem, we don't have enough lawyers to enforce these environmental laws, or the communities that most need the lawyers don't have the resources they need to hire the lawyers to enforce, say, the Clean Water Act on their behalf to stop pig crap from being dumped in their waterways from factory farms. So that was the theory. Not enough lawyers or not enough resources for the communities to hire the lawyers. So the Legal Defense Fund was essentially formed to plug those two gaps, which is to provide free legal services to communities to try to enforce these laws. As you can imagine, when you offer free legal services, the phone rings a lot. And within a couple of years, we were representing over a few hundred municipal governments and community groups across the state. At that time, in the late 90s, a lot of it was related to agribusiness. So actually it was brought home to us recently too with the recent hurricane in the south, and I'm sure a lot of folks saw the overflowing of the pig manure lagoons and all of that stuff that was being dumped into the waterways. Well, that happened back in the 90s. There was another hurricane where the same thing happened down there, and a lot of those factory farms then started coming north because they were trying to get them out of the way of the hurricane path, and that's when they started invading Pennsylvania. So we were dealing with a lot of factory farm folks back then, as well as a lot of sewage sludge. So the call was always the same, and it's almost always the same now when I get a call every week, which is you get a very energetic and passionate person on the other end of the line who says that they have a problem facing their community, and they list off a whole bunch of reasons why it is a problem and why it's going to be bad for their community, and then they want us to help them do something about it. Back then, with the theory that we opened the organization on, it was a very traditional environmental route that we would follow. And it's still the one that most major environmental groups do today across the state and across the nation. And what that meant is we would get the call, the community group would ask for help, and we'd say, we can help you, we will help you. And what that help looked like was working with the community to try to appeal the permit that had been issued for these activities. So as I mentioned in the opening thing, none of these things can happen. A factory farm can't be put in your community, the Mariner East 2 pipeline can't be put through your community, a frac waste injection well can't be put in your community unless the company that is overseeing that project has a permit from a state or federal environmental regulatory agency. So the logical thing to do was to try to appeal the permit, to try to show the regulatory agency that it was a bad idea for them to issue a permit for this thing to come into the community. Clearly, this is a bad idea to put a factory farm smack dab in the middle of this with the waterways doing this, and would become experts on hydrology and geology and truck traffic and lighting and odor control and all this stuff. The community would become experts on it, we would become experts on it, and the theory was we would then take that permit and appeal it, either to the Environmental Hearing Board or to the relevant judge, depending on where it was, and we would plead the case. And oftentimes, just by virtue of showing up in court, we would actually win that first round of permit appeals. Last I saw, about 98% of permits that are issued to corporations in this country are not actually ever appealed or even looked through. They're just issued and the corporation proceeds with the activity. It's never even challenged or looked at. So just by virtue of showing up and doing some work and looking through these things, we usually would get a win. We would identify flaws or deficiencies within the permit. We would look through it and say, okay, their wetland study is 10 years out of date, or their truck traffic doesn't take into account certain trucks that are going to be associated with the bringing in of the sludge, their bond amount's wrong, all this stuff. We would look through it, and how many folks in here have seen a permit before? Yeah, a lot of fun to look through, a lot of technical information. But usually we would represent the community, we would take the permit in there, we would find the flaws and deficiencies, and by and large, the judge or the regulators would agree with us, and they would say, actually, you're absolutely right. All these things are required to be there as a part of the permit application, and these are deficient. These are clearly deficient. These things are wrong. And so we are going to revoke the issuance of the permit, and the activity can't proceed at this point. To which everybody would go bonkers and celebrate. I mean, the system worked. The community group got active, they educated themselves, they hired they didn't hire us, but they got a competent law firm involved. We would argue competently in front of the judge, and the judge would actually listen to the arguments and then make a decision that, yeah, absolutely, this is not going to happen within this community, and we're going to toss the permit. And everybody would drink beer and have snacks around the kitchen table. Except, of course, what would happen 3 months, 6 months later is the corporation would resubmit the permit application, and this time they would have fixed and filled in all of the flaws and the deficiencies that we had identified for them. So we were essentially doing the work of the corporate attorneys and helping them build better permits. So the community group would be back on the phone with us, 6 months later and say, hey, I know it's been 6 months, but we still don't want the damn factory farm, and so you guys need to do whatever it is you did the first time. You're the lawyers here, and get this thing tossed again. We don't want it. To which we found ourselves having to explain to them that we had no other legal tools left to offer, because the legal language is administratively complete. If everything that is required by the permit application is there, if it's all there, all the I's are dotted, the T's are crossed, everything's correct, the permit has to issue. It shall issue as a matter of right. The DEP, the EPA, FERC, they don't have discretion over whether or not they think it's a good idea. They actually have to issue that permit if everything that is required by the application is there. Of course, that came as a shock to the communities, because they thought they lived in a place where if they educated themselves and if they got competent lawyers involved, that they could actually exercise some form of democratic control within their communities and get these things tossed out. And it was a hard lesson for them to learn, and an even harder lesson for us to learn, because we didn't get into this work to try to help corporations build better permits. I mean, we weren't even costing them money. They got to write that off as a necessary cost of doing business. And the lawyers that they would hire to actually fill in the permit applications would then be able to bill their clients for another round. So the attorneys were actually getting more money out of this by us actually fighting the permits in the first place. So that was a bitter pill for us to swallow too. Even more bitter, we got some pretty big accolades, national honors. We got invited to the White House under Vice President Gore for being one of the top environmental law firms in the country, because our win-loss record on paper was something like 180 wins to 4 losses, because just by virtue of showing up, we would win that first round, right? So it was bitter for us because we were getting awards, and yet if you looked at the communities that we were trying to help and the communities that we were actually representing, it told a very different story, which is that they didn't have the legal tools they needed to actually say no to this thing, and they were physically prevented from stopping it by the law. We almost closed up shop at that point because we decided we had pretty much anything better to do than to help corporate attorneys build better permits to force stuff that, forced harmful things on communities that didn't want them. And it was then that communities then began asking us a very simple question, which was why? Why is it that we can't just say no to these things? Why do we have to become experts on hydrogeology and geology and truck traffic and hire, all these experts and scientists? I mean, this is serious. This isn't just being colloquial. Like, people would pull out their copies of the Pennsylvania Constitution and point to them. Article 1, Section 2, all power is inherent in the people. So logically, if all power is inherent in the people, why don't the people seem to have any authority to make any decisions that actually stick on important, matters within their community anymore? To which we found ourselves saying, well, we don't know. We're just environmental lawyers, and we're here to appeal permits. And we didn't know at that point until we started peeling back the onion layers. I'm not going to go into too many onion layers tonight. I see a few familiar faces in the room, so people have probably heard the box talk before. But basically, what we learned, and we go back to the Magna Carta. We now do these things called democracy schools, which are weekend workshops, where we trace the history of our legal and political history in this country. And probably not news to a lot of people in this room, but our current structure of law is based on English common law at this point. The folks that wrote our Constitution, the founding fathers, were mostly English lawyers before they wrote the Constitution. And I'm not going to go into too much of that history tonight, all to say that at this point, it's our belief, and I think it's borne out every day, that our Constitution, no matter what people think about it in terms of whether or not it's been corrupted, was never actually intended to protect the rights of people or of communities. It was actually set up to protect the elite, the 1%, at the expense of the health, safety, and welfare of the people and their communities and of nature. There's nothing about nature in the Constitution, honestly. So that's our experience. We have a lot of materials to back it up, but basically at this point, there's a lot of legal things going on, I'm not gonna try to bore you too much with them, that actually prevent these communities from stopping this stuff. And so we had to learn it, and then we would explain it to them. There's things called preemptive laws. So when it comes to the Mariner East pipeline, there's state preemptive laws that actually prevent the communities from saying no to this. The state has said, you don't have authority over this at the local level. This is a matter of state concern. We can't have communities getting involved in this situation, so you're actually physically prevented from having a say over pipelines. When it comes to injection wells or frac pads, those are also matters of state concern that have said you can't have authority over this stuff at the local level. We did an analysis in my organization about 4 years ago, turned into about 120 pages, where we looked at all the times that the Pennsylvania legislature has passed preemptive laws, and it's in almost every area of your life that you can think of. Forestry, agriculture, sewage sludge, oil and gas, banking, mining. I mean, I can go on and on. Basically, the fundamental things that we need to live, to get out of bed in the morning, food, water, and energy, the state has passed laws that say you don't get to legislate or make decisions on these issues in your community. We, the smart people in Harrisburg, are going to be the ones that decide those policies for you, and you don't get to decide those things. That's beyond your pay grade. You don't have authority over that. So don't try. We're going to be the ones that make those decisions. So we had to explain that to the communities, and you can imagine they weren't too happy about that. And in addition, the rise of corporate power over the last 150, 160 years in the United States, which in short has given corporations privileges and so-called rights under the Constitution, which allow 5 people on a corporate board from a corporation headquartered in Oklahoma to have more say over a majority of people in your community want to see. They're empowered by these preemptive laws that give the corporation these rights and privileges, and then they get to jam stuff into your community that you don't want and that's going to hurt you. So we were explaining all this stuff to folks, and you know, they said, well, that's not the version of American history that we grew up with in school. And we said, yeah, it wasn't ours either. And so, you know, at that point, it's really up to the communities to decide what they want to do. Do they want to live within that system and just accept that the state has told them they don't have any control over these things? Do they want to live within that system, or do they want to defy it and openly challenge it? And it was the communities that really wanted to defy it and openly challenge it that then dragged us into the work that we're now doing, which we no longer call really environmental work. It's basically civil rights work, and it's turned into the rights of nature work as well. So I want to stop and see, I went through a whole bunch of environmental stuff there, and I want to get into the rights of nature stuff next. Is there any questions or anything that's unclear about that? Okay, good. All right, so we started working with communities at that point to not say, how are we gonna get a better deal? How can we, you know, is there a way that we can zone where this is gonna go in our community? Is there a way that we can get harmed a little bit less? We were working with the communities that said, we wanna stop this completely. We're willing to risk a lawsuit, and we wanna come up with basically new legal and organizing tools to say no to this stuff. And so we worked with about 100 communities in the early 2000s that passed bans on everything from factory farms to sewage sludge to toxic waste incinerators, coal mining, natural gas infrastructure, things like that. And then it was Kathy Miarelli who took that first step about invoking rights of nature into these local laws. And I want to take a minute to just talk about what rights of nature actually is, or what it means. And I'll put some language up that shows what some of the language looks like. But rights of nature from our perspective really is about getting at 2 different things, one legal and one moral or ethical or philosophical. Giving rights to an ecosystem, to a watershed, from a legal perspective, does 2 main things. It does 2 kind of practical things that currently are unavailable to communities under the existing environmental structure of law. So it expands what's called standing for people. It allows more people to get into the case to try to protect the ecosystem. Under the current structure of law, nature is defined as property. And because it's defined as property, you have to try to show a property interest in nature to try to be able to protect it under, say, the Clean Water Act. So if you have a house on a river and that river becomes orange because of pollution upstream and your property values go down because you can no longer sell it, you may have a claim under the Clean Water Act to say, I have been aggrieved, and try to get damages from the polluting corporation because you had a propertied interest in it, you had a moneyed interest in it. You might be able to try to enforce the Clean Water Act. Of course, in that situation, though, too, the damage has already been done. You know, the river's already polluted. So it's always on the reverse, the backside of it, too. The other thing is with damages, if you do win, say, a Clean Water Act claim against an industry that's polluting your river, and you do get money, that money goes to you, an individual, to the person. Under rights of nature, any damages against a company that has polluted a waterway or the air or something like that would actually go back into the restoration of the ecosystem, to be held in trust by the government and to go into restoration to make it whole. So it's not about any individual getting rich, it's about the restoration of the ecosystem to make the ecosystem, the environment, be healthy again. So under rights of nature as well, in addition to making the ecosystem whole, it's about increasing standing. Under rights of nature, just by virtue of living in the community, you would have authority to try to make a claim to protect the river or to protect the air, something like that. So it's saying you don't have to own property. You don't have to just have a moneyed interest in it. Just by virtue of living in a place, you should have the authority to try to protect the ecosystem, the environment upon which we all depend. So those are two very practical legal things that rights of nature does, is it increases standing, allows more people to get in, and it makes sure that the restoration of the ecosystem is what's important, not an individual getting money from a corporation. Those are the two legal shifts. From a more philosophical perspective, and the one I think is more interesting to me and a lot of the communities we're working with, is it's about seeing ourselves in a different relationship to nature as well. Under the existing structure of law, nature is seen as property. It's something that can be bought and sold and traded, and with that comes the authority to destroy it if you want. Some folks say, well, maybe you need a permit, which is fine, then you get a permit to destroy it from the state. So it's property under the law. Under rights of nature, it's no longer property. Nobody can own a river or an ecosystem under rights of nature framework. And it's really about people beginning to see that we're not separate from or lording over the ecosystem. It's about seeing us as a part of it. So there's a philosophical, a moral shift as well that comes along with it, is not seeing ourselves as separate from nature, but actually seeing ourselves as a part of it, and we're actually a part of the ecosystem itself. So those are two of the bigger shifts. I wanted to look quickly at some other language in our own state constitution, because there's been a lot of talk recently about environmental rights. Article 1, Section 27, who in here has heard of Article 1, Section 27? Okay, not too many, good. So our own state constitution in Pennsylvania, and this was passed in the 1970s, has an environmental rights amendment. It's Article 1, Section 27. And I'm just going to read it. Natural resources in the public estate. The people have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. As trustee of these resources, the Commonwealth shall conserve and maintain them for the benefit of all the people. So that sounds pretty good, and in many ways, it's a better language than a lot of other state constitutions have, even like California and stuff. But for most of the time that it has been in existence, it was dormant. The court didn't actually recognize it as meaning anything. There's been a couple of cases in recent years where they actually have said, oh yeah, actually that does have some meaning, and they've used it to limit the power that fracking companies have across Pennsylvania. But from our perspective, it still doesn't go far enough, and I want to distinguish between what the environmental rights language looks like versus what rights of nature looks like. So Highland Township is a small township in Elk County. They passed a new law in 2016, and this is what rights of nature language looks like. Rights of ecosystems and natural communities. Ecosystems and natural communities within Highland Township possess the right to exist, flourish, and naturally evolve, and that right shall include the right to be free from activities that may pose potential risks to that right, including the depositing of waste from oil and gas extraction. So on the surface, a lot of that looks the same, but a couple of things that I just wanted to distinguish between what a more traditional environmental rights language is from rights of nature. And the two main ones are the first two words in Article 1, Section 27, the people have a right. So it's still separating the people from the environment. It's the people have a right to clean air and pure water and things like that. It's saying that is there for our benefit. We have to preserve it so we don't die. But we're only doing it for self-preservation, not for the actual benefit of the ecosystem itself. And then the other piece is the third line down. They are the common property of all the people. So it still defines the environment as a piece of property, which is why it's so difficult to try to use that to meaningfully protect the environment, because then you get into competing property rights. By still defining it as property, you get into competing property rights between the corporation or the person that wants to pollute and the property of somebody else. So rights of nature is about trying to lift new arguments out of all of that and create an entirely new structure of law that sees ourselves as a part of the ecosystem, as a part of the environment, and not separate from it. And some folks say, well, that's a heavy lift. We want to do an entirely new structure of law. And from our perspective, I don't say I want to do that, But I think where we've come to as an organization is that the existing thing we have, going back to the laws that were passed in the 1970s, and even including the Environmental Rights Amendment, are fundamentally flawed. They see us as the owners of the ecosystems, and the tools that they have given us still define nature as property, which are doomed to fail under most of the other commercial laws and corporate laws that we have in this country. So that's where we have arrived at, and the communities that we work with have arrived at, is we actually need to build something new because the existing one has failed miserably and completely. I'm going to get into a bit more good news here for a minute. There's now over 36 communities in 10 states across the United States that have passed rights of nature into their local laws. Just a couple of years ago, we've now seen communities begin to try to enforce the rights of nature in court, which is the next phase of this. So I want to tell a little story about Grant Township. Anybody in here heard of Grant Township? Nobody. Grant Township is a small rural municipality of about 700 people in Indiana County, so central western Pennsylvania. 700 people, traditionally conservative coal country up in that area, and their annual tax base that the municipality takes in is $32,000 that they get in taxes. So small, rural, poor. They have been threatened with a frac waste injection well. If folks are unfamiliar with what that is, frac waste injection well is where they dump all the crap that comes out of a fracking operation. So when fracking operations happen, they come up with all this what's called flowback water, which can be radioactive when it comes out of the earth. It contains unknown toxic contaminants that the fracking corporations use to put into the ground that then comes back up. They have caused earthquakes in places like Ohio and Oklahoma and California. These things have actually been shut down. And so they're nasty things. Like, they have polluted water, they've caused earthquakes, and it's basically using your community as a toilet. The frackers would bring this stuff in and inject it into the earth. The company that wants to inject in Grant Township is a company called Pennsylvania General Energy. They are one of the top 10 permit violators in Pennsylvania. So they, aren't really good corporate neighbors. They have a history of violating their permits across the state. So this is a company that wants to put in a dangerous activity already. The community doesn't want it for obvious reasons. And so they thought, logically at first, that the EPA would clearly see this as a bad idea and not issue the permit. Of course, the EPA did issue the permit. The community appealed the issuance of that permit. The EPA denied the appeal. Then the DEP issued the permit as well. So it requires two separate permits, one from the Environmental Protection Agency and one from the Department of Environmental Protection. And it was at that point that the community got in touch with us because they basically saw that the state and the feds were not giving them any help and they had no other tools left to fight with. And so we worked with them to pass an ordinance in 2014 that banned the injection well within the community as a violation of the community's rights and as a violation of the ecosystem's rights. So there was rights of nature passed into that law. Predictably, they got sued by PGE in federal court. And PGE claimed that the community didn't have the authority to pass this law because they were preempted by state law and federal law, and because PGE has corporate constitutional rights. We didn't get into this too much. I'm not going to bore folks with it too much, but just to say that PGE and other corporations have constitutional rights under the First Amendment to free speech, Fifth Amendment rights to due process, 14th Amendment rights to equal protection. So one of the things that PGE was claiming in that lawsuit is by Grant Township banning this injection well, they were violating PGE's 14th Amendment rights to equal protection. So equal protection, the 14th Amendment passed after the Civil War to make sure that the law applied equally to blacks as well as to whites. PGE was saying, by you not letting us put this frac well in here, you're treating us differently from other businesses within your community, and therefore you're discriminating against us and violating our rights. That sounds crazy. It happens every day. I mean, these types of rights are exercised against communities every day in this country, but I'm just using Grant as an example right now. So that case was in federal court. The judge, Judge Baxter, Susan Paradise Baxter, up in Erie, ruled against the community about a year later in October of 2015. And she said, yeah, you're right, PGE. The community actually does not have the authority to prohibit this because it's a state and federal matter, not a local matter. So she grew to PGE. It's also worth noting that 1 month before this judge took the case, she possessed stock in Halliburton. But because she divested it, everything's ethically okay now. So this judge ruled against them in October 2015. In November 2015, the community, Grant Township, then passed what's called a home rule charter. They basically formed a new government and said, fine, you overturned our ordinance. We have now put a new charter into place that the entire community has voted on. And so they put a new law into place that basically looked at the judge's original decision and said, we don't agree with that. We're going to put a new law back into place, and they banned the injection well again with a new charter. They changed their form of government. So now there's a ban in place again. At this point, the State Department of Environmental Protection sued the community in state court. So just to reiterate, the State Department of Environmental Protection has sued Grant Township for trying to protect its environment. The State Department of Environmental Protection has sued Grant Township for trying to protect its environment. So, and their argument is that the State Oil and Gas Act is a state policy, and it preempts the municipality, and therefore it's interfering with DEP's ability to carry out its job by enforcing the State Oil and Gas Act if these local communities are enacting these local laws. That's their argument. We're still actually in court over that right now. There hasn't been a ruling. We're going through discovery, all that stuff. Meantime, the attorneys for PGE asked the judge to sanction our lawyers in that case. They said that we were making frivolous and improper arguments. The judge actually, in an unprecedented decision in many ways, agreed with PGE and fined 2 of our lawyers individually for $52,000 for having the gall to represent a community that is trying to protect its drinking water from a polluting corporation. In addition to that, PGE is now asking for attorney's fees. They're claiming $700,000 in attorney's fees. They're claiming that they're being nice and they're only going to ask for $100,000 from Grant Township. We're waiting for a decision on that from the federal judge at this point.
Didn't you say you were giving us good news?
Yes, it's coming. But in many ways, this is one of the clearest examples that we have of how the system actually works, where you have a federal judge, the company, and the DEP all working in lockstep to try to force this community into submission and to punish the lawyers that are trying to represent these folks in court. It's what we call a corporate state. I think this is the clearest illustration that we have seen yet of how all of these forces actually work together, and that also the courts are not impartial. I know a lot of people believe that they are, maybe not in this room, but. So the good news. In 2015, for the first time in the United States, an ecosystem made a motion to intervene in court in that case. The Little Mahoning watershed in Grant Township, represented by 2 local residents there. As you might imagine, the judge didn't allow the ecosystem to intervene, but the judge also didn't allow the community group in the township to intervene into the case. So she wasn't just discriminated against the ecosystem, she also was discriminated against the people of the community. That inspired Highland Township, which is where that language is from, to also try to intervene in their case. They were getting sued over an injection well as well by a separate company, Seneca Resources. And in that case, it was the Crystal Spring watershed that attempted to intervene into the case as well. The judge didn't allow the intervention there either, but she also denied intervention for the community in that place as well. However, that's now given rise to a community in Oregon, in Lincoln County, which last year passed a ban on aerial pesticide spraying. And the ecosystem there has made a motion to intervene in the case. The judge still has not ruled, but actually in the oral arguments admitted that it was possible that this is a legal theory that may need some further consideration. So at least it wasn't a straight no. In addition to that, last year, about 8 or 9 months ago, the Colorado River sued the state of Colorado for violating its rights to exist and to flourish and to thrive. The case didn't go all that far, but it was just a further expansion of watching how rights of nature is beginning to move out of the communities and actually into the courts at this point. Currently in Ohio, there's a community that's putting up what's called a Lake Erie Bill of Rights. The Supreme Court in Ohio at this point has prevented the people from even voting on it. So we can see that they're beginning to take it seriously when they won't allow things to even go up for a vote, and when they're also sanctioning the lawyers that are representing the communities. So that's a little bit about domestic stuff. I think it's pretty exciting. I mean, to see it move from just a theory or a concept into the courts and to see communities actually beginning to try to enforce these rights, it's pretty interesting stuff. Internationally, did you pass those out, Melinda? Oh, thank you. This is a timeline. I'm not going to run through all of it, but just to also illustrate that this work's beginning to expand and accelerate internationally, in many ways at a greater speed than it is in the United States, even though it started here. You can see the third bullet point from the bottom says in 2011, a campaign was launched in Nepal to advance the rights of nature. Today, we're working with members of parliament there on a constitutional amendment for rights of nature. In 2012, we started working in India. And actually, just this last year, the Ganga River was granted certain legal personhood protections by courts in India. I'm going to move to the next page. About halfway down in 2017, Mexico City incorporated language into the city's constitution, which would be about protecting the rights of nature formed by all its ecosystems and species, a collective entity subject to rights. Next bullet point below that, 2017, the New Zealand Parliament finalized the Te Awa Tupua Act, granting the Wangway River legal status in an ecosystem. In 2017, the High Court of Uttara, I don't know that word, I'm not even try, in India, issued rulings recognizing the Ganga and Yamuna rivers, glaciers, and other ecosystems as legal persons with certain rights. And then the very bottom bullet point, in 2018, just earlier this year, the Colombian Supreme Court recognized the Colombian Amazon as a subject of rights. And then just last week was the 10th anniversary of the rights of nature being passed into Ecuador's constitution. And the week before that, the Ho-Chunk Nation, a tribe located in what's now Wisconsin, had its general council voted to amend their tribal constitution to include rights of nature. So that would be the first tribe in the United States to do that as well. So just to say, something that started from some bold actions in 2006 by people in rural Pennsylvania has now in many ways spurred and initiated a global movement for the rights of nature. I think that's all I'm going to say on this stuff, and we can get into some discussion at this point. There is a documentary coming out probably later this year. There's some pre-screenings that are going to be happening this fall that is featuring rights of nature, and it's going to tell the story of Grant Township as well. I am a little shy to do it because I have a couple of parts in it, but I'm going to show a trailer from that right now because folks may be interested to check it out on their own and download it at home when it comes out.
It's about the water. It's always been about the water.
The citizens of Grant Township, Indiana County are on the forefront.
If a corporation has the same constitutional rights as an individual, why couldn't an ecosystem?
En el campo del reconocimiento de la naturaleza como sujeto de derecho es revolucionario.
What you're saying is really, I think, in the beginnings of an international movement.
Indigenous people are really conscious of this land. We're trying to wake people up.
This is the beginning of a legal system in favor of nature.
Were you aware of the risks and the potential that you were going to be sued and all that at the time?
We were aware ahead of time that we were indeed going to get sued, but we just went ahead with it.
If you lived in this area, would you want the injunction well in your area?
Okay, answer the question.
We don't want this harm in our community. There's no benefit to anyone here.
Our environmental regulatory system isn't actually there to protect us.
We can't rely on our legislatures to protect us. We can't rely regulatory agencies to protect us?
The front lines. The front lines is everywhere. If there is a resource extraction happening next to you, you could do something to stop that.
The people of the township are the legitimate decision makers here tonight.
We don't have an injection well problem. We have a democracy problem.
We have shifted our government to one that's now become totally corporate control.
The struggle in Grant Township is our struggle.
Either you stand up or you don't.
Remember, the corporate goal is to make sure democracy doesn't exist.
It's not an environmental movement unless it protects nature as a rights-bearing entity.
That's all I got. Any?
So again, as a reminder, like it's an extension of your face. That's how to use the microphone. Questions?
It is always a pleasure to hear you to talk with so much passion about this issue and seeing the development, from the different years and that you have been sharing with us your story. I used to work in Costa Rica, a country which environment is highly protected, not necessarily under the same mechanism, but very similar, yeah? And also thinking about other countries in Latin America where we have faced in the last couple years a tremendous violence against people that are involved within the environmental movement. Indigenous leaders trying to do the same that Grant Township was doing, for their community has been killed. Journalists covering this issue also has disappeared in many places like Mexico. We can name so many countries. And my question is, has the United States or communities that are facing this issue in our country right now face similar type of violence against people, not only nature itself, but against the people that are trying to do the right thing, to build the relationship with nature?
Yeah, I don't think the violence here is as outward as it is in a lot of Latin American countries that you mentioned. In many ways, I think the violence here is more insidious because we can't see it in a lot of ways. That said, I mean, Standing Rock, there was a lot of violence inflicted on folks that were there. And I guess in Melinda's county, I guess it wasn't state violence, but there was over 60 people arrested down there trying to stop the pipeline. In Grant Township, actually, a piece of the story I didn't mention, their elected officials, their supervisors, have been threatened by the oil and gas industry with criminal prosecution at this point for so-called violating their oaths. They're saying that they're passing knowingly illegal laws and therefore affecting the financial health of the community in a negative manner, and they could actually be jailed. To which Grant Township responded by passing another ordinance that legalized nonviolent civil disobedience within the community. So they push back and continue. But I think it's hard because there's not that overt violence, and I don't think it's as, in many ways, in our faces as it is in other countries. At the same time, that makes it harder for people to see how violent the system still is in this country because we think that we have more protections or powers than we actually do. And that's a lot of the work that I do as an organizer, is I'm working with a lot of rural, often conservative, white communities that are used to being privileged or benefited by the system until something like this comes in. And so it's helping, you know, those folks see that the system actually is not acting in their interest, but is actually actively working to violate their rights in their best interest. So I haven't seen that same overt violence, but I think it operates in other ways. In many ways in this country, I think it operates in our heads. I mean, you know, we have been so colonized to believe certain things about the founding fathers, about the Constitution being the greatest governing document ever conceived of by any group of people ever in the history of the world, and, you know, for now until, you know, infinity, the future too, that it was a blessing, you know, all this stuff, it's in our brains. And, you know, I think it was Sally Kempton, she was a feminist author, she said, it's hard to defeat an enemy who has outposts in your head. And I think that's where we're at. Do you want to?
I don't know if anyone's familiar with SB Senate Bill 652, but Senator Regan, with a bunch of co-sponsors, passed it in the Senate. And what it does is it makes even peaceful protesting at what they're calling critical infrastructure a felony, with $10,000 and $20,000 fines for first and second offenses. And it just went through committee in the House, and they put some amendments on it, and it hasn't come up for a vote yet. But the other one is SB 754, which is requiring anyone who's arrested to pay for the emergency response to their protests. So when we were doing protests in Lancaster against the Atlantic Sunrise Pipeline, they sent out, you know, we'd have 60 people holding hands, singing songs, singing Christmas carols and handing out Christmas cookies. And they'd send out 20 cars of police officers to come out, you know? And I feel like they were sending more people than they needed as an excuse to say, look at all of the resources these protesters are causing the taxpayers to pay for. And then when we're arrested, we do pay fees. Like, not only do you pay your fine, but you pay a fee that goes towards paperwork and everything, you know, the people coming out. So we're paying extra fees, but they want to slap $10,000, $20,000 on top of us, and whatever it costs for the enforcement to come out. So those are other ways of pushing back legally by bullying and intimidating people from exercising their constitutional rights.
I'm wondering if you have thoughts on a long-term effect. Like, let's say we get a federal law that protects the environment as its own entity, like you talk about. How do we, or what's the ideal scenario then? How do we prevent it from, you know, then the dumping just happens in another poor nation, or whatever the alternative would be?
So I think a lot of the stuff would come back to the decisions being made at the community level, and communities being forced to be responsible for the things that they're producing. I mean, right now, industry, it's easy for them to dump it somewhere else. And really, they only tend to change their actions when it's either too egregious to ignore, like a river gets set on fire, or they actually contaminate a water supply. And so, from our perspective, if communities, you know, and nature does have rights to exist and to flourish, I don't think it's about dumping it somewhere else. It's about communities taking responsibility in all facets of their lives for what they're producing, the type of waste that they're producing. And it doesn't mean sending it somewhere else. It means that you actually take responsibility for the ecosystem. If you're seeing yourself truly as a part of nature, then it's about recognizing that you can't produce something that is going to harm nature somewhere else if you can't deal with it in your own community. So I think that's a part of the philosophical and the ethical shift that would need to go along with this. You know, not just a not in my backyard type of mentality. That's not what this is, you know, about at its core. So.
I'm not clear how this works legally. So if we grant a river rights, and a corporation already has rights, and they come to a court, who wins?
Well, in the laws that we work with communities to draft, they don't recognize corporations as having rights that would allow them to violate the civil rights of the people of the community or the rights of the ecosystem. So in many ways, it's about redefining corporations as well and not accepting the definitions or the terms of the protections that we're told that they have. And so it's a direct challenge to that as well, which is saying we're not going to recognize or authorize corporations to have these rights in our community that would supersede our rights or the ecosystem's rights. And so a lot of the language that we have, both at the local level and the state level, is about redefining businesses, redefining corporate entities. And it's a form of rebellion, too, to say, we're not going to accept that corporations have rights to equal protection. That's crazy. I mean, you know, when you actually explain it and put it out there, it's crazy that they have rights to be free from discrimination when they want to dump something harmful in your community. And so it's redefining those things. And a lot of that is about recognizing that large economic actors right now operate outside of the control of the community, the state, or even our federal government, like NAFTA, you know, free trade agreements. Those agreements authorize corporations and business entities to actually, you know, interfere with the health, safety, and welfare of entire nations. You know, there's these private trade tribunals which can try a government like the United States in court if they interfere with some of the free trade agreements like NAFTA. So we have privatized most of the decisions relating to businesses and corporations. This theory and the work that's being done is saying if those businesses or corporations are engaging in activities which violate our rights, we don't recognize them as having those legal protections. They're subordinate to us. They work for us. And this isn't some crazy legal theory either that's just being concocted out of this movement. I mean, after the revolution in this country, corporations were really, they had to come hat in hand to the communities that they wanted to serve. Because before the revolution, you had large corporations like the East India Company, which around the time of the revolution actually had a larger private standing army than the British government itself. And the colonists here were very wary of the power of these large corporations, and so they really put a lot of controls and restrictions on them. Like, if you were going to have a company, it had to be for a very specific purpose, like a ferry operation or building a road or something like that. It existed for a specific amount of time, so, you know, the amount of time to build it and then to make a certain profit afterwards, at which point it would be dissolved. That the people that served on that corporate board had to exist within the community that that corporation was operating within. You know, there's a lot of controls put on them that we don't have these days. Corporations have perpetual life. Doesn't matter where they're chartered, you know, they can still come into your community against your will. You know, they can make as much profit as they want at your expense. So it's not something new, but it's about redetermining and reframing how these economic actors operate within our communities and recognize that community rights and nature rights are simply superior to corporate or business rights. That's it.
Yeah, I was hoping you could speak to if any of these communities have inter-conflict about the corporate interest. In Oregon, where I'm from, Hood County just passed a referendum, the county did, to ban Nestle from Oxbow Springs because they want the water from Mount Hood, billions and billions and billions of gallons to bottle and sell. And Cascade Locks, which is a town within that community, passed their own referendum trying to usurp the county's vote, saying that the county, you know, had banned the water. So I guess, have you encountered anything like that where there's, you know, the community is like, no, we don't want something, and then somebody in the community, you know, says, yes, we do?
Yeah, definitely. I mean, we see it a lot with fracking stuff in particular, where people think they're going to make a lot of money by leasing their land for fracking. And so people, large landowners within the community would lease their land. And, you know, there's this private property rights stuff in the United States that we're taught is sacrosanct, that it can't be infringed on. I mean, our perspective on that, and that comes through this work, is saying private property rights are fine, but you can't do something on your property that would violate or infringe on somebody else's rights to enjoy the place where they live around there. And so I think in the situation you're talking about, there's a conflict, which is, you know, how many people are actually interested in putting the, you know, and actually withdrawing the water? Is it one or two large landowners or people that are going to benefit economically? And then also, is that withdrawal going to violate the rights of the other people living around there to enjoy that water, to have drinking water, to have recreation or things like that? So I think that's the balance. You know, and some of those balances are going to be difficult. I think those are better discussed and resolved at the community level rather than at the state, you know, the people that are most affected by the decisions. But yeah, there is going to be some conflict. Right now, the problem from our perspective is that you often have one or two large landowners or one or two large economic actors that have a disproportionate amount of power to allow something to happen within the community that violates the rights of the rest of the people living there. And that's what these things are shifting.
So you said that the rights of corporations were denied by these local ordinances, but isn't that also preempted by the state or federal laws, and so shouldn't the change really be worked on at the state and or federal level to make that really work? I still don't really quite understand how that would still work in a court of law.
Yeah, so a lot of this, it's a great question, and we are beginning to work at the state and the federal level. It's our perspective in looking at a lot of people's movements in this country that most meaningful change that's been made at the state or federal level has first bubbled up from grassroots movements. I mean, abolition was 70 or 80 years. Women's suffrage movement was even longer than that. Gay rights, same-sex marriage was a recent one, 30, 40 years. But most of that stuff started local. I mean, we can see with same-sex marriage in particular, it was the states that were really pushing that forward. Same these days with marijuana legalization, in direct defiance of federal law to the contrary. So that's what this stuff is doing, is it's attempting to really work with communities at the grassroots level, because we understand the communities right now don't have the power at the state or the federal legislatures to actually influence the legislation. It's going to have to be people that force it to happen. And so, our theory of change and, is looking at how constitutional change has happened on behalf of the people in this country is it happens first at the local level. And it's also about creating a new DNA, a new vision for what that law should look like, so that it's not about compromising when we get there. The first conversation I ever have, when I go into a community that calls me is they want to talk about, how can we win, what are our best options, stuff like that. I see my role as saying we can't start from a place of what can we get, because that immediately places us on defense and assumes we're going to get something and we're just figuring out the best deal we can. It's starting from a place of what do we want? What is the future that we envision for our community? And actually thinking that through and putting that into law. So even right now, if the state or federal government says you can't do this and redefine corporate powers like this at the local level because this is a state matter, the communities are saying, well, we do think we have the authority at the local level. We have a right of self-government, but also we're beginning to create models for a newer and better and saner constitutional structure when we get enough communities to actually force that up. So we're actually, Melinda and I have been at the legislature on behalf of a number of communities over the past several months, working on a couple of constitutional amendments that would be about giving communities the rights to say no to these harmful projects and about recognizing the rights of nature. In New Hampshire last year, it was introduced by a bipartisan group of people, about 10 Republicans and Democrats, a right of local self-government constitutional amendment at the state. It got about a third of the support of the entire House, so it got much further than we expected at this point. It's being introduced in Ohio and in Oregon and in Colorado at this point as well. So to your point, I agree, we do need to move to that level. The question for us always was, how many communities do we need to be able to force that change, because we don't have the money. It's going to have to come from people power.
So I have a question. I'll pass it to you, Joan. Sorry. Intercepted. The example I've often heard about why it's better for the federal government to be in charge of some of these things is the example that's always wheeled out is the civil rights movement, and the fact that where you had local states, local governments wanting to oppress people and keep segregation and all these things, what was needed was a federal law that could then be enforced down upon the states. So how do you combat the potential of local control and local laws being discriminatory, being oppressive, and how do you balance that history when you come into communities, but also just looking forward, what do you see?
Yeah, thank you. It's a great question. I think number one, I think we need to be cognizant of our history with this question. Not like you're not, but recognize that historically our federal courts and federal government have been the upholders of oppressive laws and not the protector of people's rights. Historically, they have stood between the people or stood against the people and upheld property rights of slave owners for a long time. They had the opportunity after the Civil War to view women as people under the 14th Amendment's Equal Protection Clause and 15th Amendment Suffrage Clause, but they didn't. It took another 50 years, 60 years until 1920 before women got the right to vote. Under civil rights even, a lot of the stuff that was happening in the 50s and the 60s, the federal law that eventually ended up getting put into place was not about protecting the rights of African Americans. It was based on Congress's ability to control commerce. They were looking at things like transportation laws and things like that that cross state lines. So it wasn't actually a rights-based thing that eventually ended up getting put into our Constitution. It was that you can't prohibit people from traveling on buses or staying in inns and things like that because those are commercial. So it wasn't still about protecting rights, and that's where we're getting at. But I guess just to say, historically, our state and federal governments and the courts are usually acting on behalf of the oppressors and not the people. That said, the stuff that we put into our local laws and into our proposed state constitutional amendments does place a limit on local authority, because I think it is a real concern that there are a lot of local governments out there that may try to use expanded authority to discriminate or to hurt certain classes of people or things like that. So under the laws we say you can't use local authority to violate or infringe rights that are already protected by the state or federal constitution. So it's about using the local authority to expand and further rights and protections, but it can't be used to restrict rights or protections that are already protected under the state Bill of Rights or the federal Constitution's Bill of Rights. So right now, we talk about those things as being a ceiling that communities can't go beyond. You can't go beyond the state constitution's limits on pollution. You can't go beyond it. You can't pass better protections. We think it's fine to have those limits, but those should set the floor, and communities should have the authority to go beyond those things if they want to further protect health and safety. So it's in many ways about refiguring our government, seeing the federal government's role as providing a relatively limited perspective or role of protecting basic fundamental rights and allowing the states to go further and then the communities even further. But that the local communities can't use their authority to violate rights protected at the state or the federal level. So that's how we deal with that.
When we were speaking with a senator, he said, well, if you give communities rights, then you're going to have this willy-nilly laws, like some people want a pipeline and some people won't, and then what are you going to do? And I was thinking, yeah, then what are we going to do? If the company can't find a line to put the pipeline in, maybe we would look for other energy sources and other ways. Yeah.
I was really incredibly surprised when I noticed articles in our local Town Talk, which is not known to be a liberal rag, about the pipeline and the fury of people about the pipeline. And I'm wondering how it's being covered in other places. Are you seeing interest in covering it from any sources? I will say I'm one who has a very dim view right now of journalism, unfortunately, and I have a brother who's a good journalist, and he's also upset. So I'm curious, is there anyone asking you any questions that are going to result in some kind of interesting news around the state?
No. I mean, so don't get me started on that. I mean, so I was on a panel this last weekend with a woman named Melina Abdullah, who's one of the founders of Black Lives Matter, and she's a professor in Los Angeles. And this kind of question came to her as well. And she mentioned Pacifica as being a reader-supported media organization. But I think what she was basically getting at, and what I tend to agree with as well, is we need to be creating our own media and not relying on existing outlets, even like NPR. I mean, you know, there was, before the revolution, the Sons and Daughters of Liberty, there was the broadsides. I mean, these people didn't have Facebook and Twitter, and yet they were extremely informed and well, you know, they knew what was going on. They were passing stuff around. And so I think we can't be waiting or hoping for the existing journalists or the existing outlets, even those that may be more progressive, to get our story out. If they do, great. I mean, like in the case of Melinda's work, the Washington Post and a bunch of international outlets did glom on at one point, but it was often because there was nuns involved. There was an angle that was interesting to them. It wasn't necessarily about the pipeline fight. It was a novelty, I think was my take on it. So we've got to stop thinking that somebody else is going to do it, and we've got to begin creating our own things.
I actually have one more question. Sorry. I just keep thinking of them. Mark and Paul Engler have written a book called This is an Uprising. And in it they posit that, you know, our task as organizers is always to think about shifting the political weather of what's seen as possible. But there are these moments of whirlwind where you can kind of have breakthroughs where you know, Occupy Wall Street happens, and suddenly, you know, whereas in 2007 you're fighting to raise the minimum wage by a couple of nickels, a $15 minimum wage was suddenly possible. Like these moments of upheaval where new things can break through and we can leap forward. And one idea that's been percolating and bouncing around many different organizing circles and activist circles that I'm a part of is, should we have a constitutional crisis? Should we have an executive that refuses to leave office when seen as, when we attempt to remove an executive from office and perhaps they refuse? Or any number of crises that might be in the future of the US government. Both in these moments, there's an opportunity both for sort of these far right things to burst forward and these visions of the far left to burst forward. And I guess my question to you is, do you guys have like the go bag or the thing in your pocket for like, when the whirlwind happens, what would you be hoping for from the communities you're organizing, and what would you see as the most progressive or visionary outcome of that whirlwind that you would be ready to push for?
Yeah, I mean, I think that's a lot of the day-to-day grind of the organizing work of the communities, is building up the consciousness and building up the numbers of people that understand that there are problems, whether we have a crisis or not, and that there's enough of an educated group of people that's able to capitalize on that energy and provide leadership to other folks that are looking for new ways of interacting in their communities. I mean, at base, this stuff, in some ways, you know, is less about the federal government and more about communities really taking control of their futures and their destinies, irrespective of, you know, what's happening in other places. I mean, speaking personally, I think we're too damn big as a nation or as a country to meaningfully govern. And so in a situation like that, you know, a lot of these local laws that we work with communities are called community bills of rights, but we also talk about them as local constitutions. It's about envisioning what a new form of government, a new form of social interaction, a new social contract would actually look like that is sane and that is based on the values of the community and not the values of somebody else or some other group that's being forced on them. So I think, you know, those are the models that could be provided in a situation like that. If there is a mass uprising or an opening for people to get involved in a more meaningful way, is to look at the communities that have been doing the work. And that's not like my organization's, you know, fight at that point. It's really the communities that are involved. But I think the more people think about that, the more creative options that they think through, I think the better positioned communities would be in a situation like that to take meaningful advantage of it. And I mean, it's about self-government. It's about ownership of our decisions. It's about taking care of ourselves and our community and of the earth. And usually when we start talking about lawmaking or things like that with folks, it's just blank stares. We have been so disempowered, I think, in our political participation to think that most of our participation comes down to voting for one person from two different parties every 4 years. I mean, that's really what I think most folks are doing. And so I think it's about, you know, helping to educate and get people more involved in the political process so that we actually have some basis to work from when we have more freedom to do that. So. Yeah, a lot of people worry about that stuff, and I understand. And I mean, I'm a white guy, and so I have the most privilege, and I understand that my perspective, is informed by that. But a lot of people fret, like Scott Pruitt and stuff like that in the EPA. I know he's gone now, but most of the communities I work with were not better off under an Obama administration than they were under the Trump administration. Some regs were rolled back, maybe some things got intensified, but I think we get so focused on a couple of particular agencies and hoping that getting the right person in power, the right person in an agency is really going to solve our problems. And from our perspective, it's systemic. It's not about one person. It's not about one agency. And we have been disempowered to give our decision-making authority away rather than to claim it and to say we are the legitimate decision makers here. We're the ones that are the experts, and we know what's right for our community, and we're going to act on that premise.
Thank you so much, Chad. And before folks leave, I have a couple of quick announcements. One, if you haven't signed in, please do sign in before you leave. And then a couple of upcoming events and a note about our next First Monday lecture. Our next First Monday lecture will be with George Lakey, long-term social movement theorist, has a new book coming out, which I believe the title is How We Win. And it's all examples of social movements, from the grassroots, winning these big changes, particularly in moments of polarization through history and some applications for today. So that will be November 5th, the first Monday of November 5th, 7:30 to 9 p.m. Highly recommend, right back here in the barn. And then a couple of things happening between now and that next lecture. We are in a season of liberation here at Pendle Hill. As a theme for all of our programming for this coming year, we're exploring the theme of liberation. This coming Saturday, October 6th, we have a full-day arts workshop around art for liberation, using some collage and mixed media. There's a flyer on the table in the lobby if you'd like to see that. That's from about 9:30 a.m. to 4 p.m. And then Sunday, we have our regular poetry coffee house in the art studio. Come and share a poem, come and hear poems. There are refreshments. It's always a fun time, open to the community. And then sort of a highlight of some of that liberation exploration will be Within and Without, Liberation Theology at Work in Social Movements. And this is a conference here at Pendle Hill, October 11th to 14th. We have workshop leaders and plenary speakers from all faiths, and it's really just going to be an amazing program exploring not only how liberation theology has informed our social movements in the history, but how people are applying that work today here in Philadelphia, in Georgia, internationally. So please do consider joining us for that. The full program and the leaders are available on our website, and there are also flyers in the lobby. And if you have questions, you can always corner me. Happy to answer questions. So thank you all for coming out tonight. We hope to see you November 5th for our next First Monday lecture with George Lakey, and hope you have safe travels.